Hey guys, Devin Norcross here, Norcross Consulting Services. And today I want to talk a little bit about judgments and the legal process of collecting debt and statute of limitations. Okay. So, number one, it's important to understand there's really two different areas where time impacts how long something can be collectible. So, the first thing is the Federal Trade Commission statute on how long something can be reported to your credit report. That's 7 years. That's 7 years, what we call the date of last activity. So, as long as you don't touch it, 7 years later, it's going to fall off your credit report unless they put a judgment against you. In most cases, that does not happen. But for those cases that it does, we're going to talk about that. Now, let's say you do have outstanding debt and you do set up a payment plan or make a partial payment or full payment. You update that date of last activity, you allow them 7 more years to pursue you for that debt. Now, for the purpose of this video, I really want to talk about what happens when you are at risk of getting a judgment or getting a judgment. So the first thing to understand is that every state has its own statute of limitations on debt collection. This is typically set up by the Attorney General. And I can share my screen here, give you guys an idea of what we're looking at on that. If you just Google your state and statute of limitations on debt collection, you'll be able to find that very easily. This is a website that I found is the second post down. It's got every state statute of limitations. And what you'll see is some states have very high statute of limitations, like Louisiana, Hawaii, Rhode Island. That means there's 10 years for them to come after you and put a judgment against you, even if the item is no longer on your credit report. And some states are very low. You have Maryland here at 3 years, Kansas here at 3 years. Looks like California at 2 years for some items, which means if outside of that time frame, it can still be reported on your credit report, but they can't take you to court, use the state supply judicial system to forcibly collect on you. And the main ways we see forcible collection is through wage garnishment, bank levies, and liens against property, personal property. Now, this is important. You know, you might have a state like Hawaii or Alabama or Tennessee where you have a 6-year statute of limitations and you have a very large debt. Maybe it's a repossession debt or something of that nature. If you're outside of your statute of limitations and you don't have a judgment against you, you know, then you have to find the whys and the hows and whys of should you pay this debt? Is it in your best interest to pay this debt? There are certain times where I'm advising my clients, don't pay that debt. I've also had clients with large amounts of debts, very close to falling off their credit report permanently, not in judgment status, and they're being urged into a Chapter 13 or a 7 by a bankruptcy attorney. Bankruptcy attorneys have an invested interest in you filing a bankruptcy, whether that's in your best interest or not. Okay. My clients that do have judgments, it's okay. We could still work with them. Now, the best situation is that you're able to work out a settlement with the creditor or the law firm collecting on behalf of the creditor before the judgment enters judgment status. You will usually get a summons to court. Now, I believe this to be a very flawed industry. Most of my clients that have judgments didn't ever receive a summons. If you did receive a summons or know someone in this process, the most important thing is that you show up to court. Not showing up to court is a kiss of death. You enter an automatic plea of guilty. You are liable for the entire amount. Very important at that point to show up to a judgment proceedings request. At that point, the court then can work out either settlement there on the spot or a payment plan. The court is usually very much in your favor. They want to see people paying their debts. So again, if you do receive a summons to court, make sure you show up. Now, let's say you have a judgment. Judgment can be on your credit report for 10 years. Most states will allow you to reapply for that judgment status for 5 years. Okay. This happens rarely, but it can happen. Judgments can be put in bankruptcy as well. Okay. So it is something that we see happen with a lot of judgments. I have a very close personal friend here in Denver. He's got about 36 different judgments out. 3 have paid, about 20 have filed bankruptcy, and he expects the majority of the other ones to file bankruptcy. Very few judgments seem to actually get paid, unfortunately, but they can do that bank levy. They can do that wage garnishment. You cannot buy any kind of property right now, or you cannot finance any property with an outstanding judgment on your credit report. Okay, that's a primary lien. They will not allow that. Now, what do we do if you have a judgment? We've had a lot of success here settling judgments for our clients. If you're a lender, you're a bank or mortgage company you work with, they may or may not electively add the 4th credit bureau to the credit applications you pull on your clients. That 4th credit bureau is called LexisNexis. If anyone out there wants to see their own LexisNexis report, you can apply for it for free. It will show public records. It'll show past employment history. It'll show past addresses. I pulled my own. I was blown away by how much information they tracked on me. But that is the Fourth Credit Bureau. That information is not interpreted by the FICO scoring models. So your score is not impacted by what's on that. However, public, employers will often pull it, certainly military for, promotions to E3, E4, E5, any kind of access to classified information. They're going to be looking at that kind of stuff. Certainly banking jobs, stock advising jobs, series 6, 7, whatever. They're typically going to be pulling a LexisNexis credit report. But we've had a lot of success settling public records and getting satisfaction and releases for judgment. So if you do not have the LexisNexis report, these judgments a lot of times are not going to show up until your title company does a public record search. So really important that we identify this stuff as early as possible in the loan process. I've settled a ton of these. I've got another example here on the left. This was a release of judgment for a client in Illinois. And we actually identified this judgment right before closing. And we had a settlement of $5,000 debt for $1,500. And we had this judgment satisfied and released within 72 hours, kept our original closing date. So this was a fantastic one. Over here, this is a little bit different. This is the topic, but this is a home equity line settlement. We settled a $149,000 home equity line for $59,000. So because the settlements are huge. If you're not getting this kind of service by your credit restoration or repair company, if they're just disputing accounts, it's very limited. It's not full repair. So a lot of deals have fallen apart because judgments popped their head up, right before closing with the title company. Of course, again, if you are seeing that LexisNexis information on your credit report, you are probably getting a little heads up on that. But I would say over 50% of the reports that I look at do not have the LexisNexis information. So for the real estate agents out there, for the mortgage lenders out there and bankers, if you do have judgment related issues, it's not a deal killer. We can settle these judgments. You just got to work out a deal with typically with the law firm representing the creditor. The creditor very rarely will speak to you in this case. Sometimes the creditor is the one filing the judgment. We settled one with Professional Finance Corp, which is a collection agency locally here to Greeley, Colorado this week. So I guess that's really what I want to talk about. Public records, if they're on there for 10 years. They can be resubmitted for 5. They can be included in bankruptcy. The most important thing is to try to keep that out of public record. This is really the only scenario where I recommend making payment plans. Making payment plans are always going to update your date of last activity. I don't like it on collections. But if my client has received a summons to court and I can set up a payment plan with that creditor to stay that judgment until we can find enough capital to settle with the original creditor, it's going to be an excellent strategy for the client. That's it. If you have any questions about this, you'd like to discuss it in more detail, let me know. If we're not working together for credit repair, please reach out to me. I'd love to do a presentation with you. I've got a fantastic PowerPoint. If you have interest in talking about your personal debt issues, please let me know. If you do have a judgment, this is stuff to get ahead of. All right. Don't let that stuff just stay out there. Just because they haven't levied your bank account or contacted your employer yet doesn't mean they won't. All right. So guys, that's it for right now. I really want to appreciate you for checking in, and thank you very much.